We're live.
All right, we are back in Senate Judiciary. We have the Defender General with us. It's February 25th. Got 10 minutes, and then we got to shift gears to 193. But just wanted to get your perspective on 203.
This isn't a big concern to the Defender General's office one way or the other. I think anytime you tinker with DUI, you tinker with thousands of cases. Not necessarily in the public defense system because we don't get them as much. The DUI ones usually resolve for fines, so they don't end up in the public defense system. And what this, as I understand it, and you can explain this to me, what you're getting at, and it's good to get certainty about what exactly, when the 20-year window closes on a DWI-2. And you chose in the bill to have it be, I think, the incident that gave rise to the first and second charges, right?
The incident, so long as there's a subsequent conviction tied to that incident.
Right. The only thing that I wonder about, and honestly, I don't care. I think you might be making it harder on the state's attorneys. Not that I need to argue their side. But when you're doing that second charge, it's really easy to go in if you're the state's attorney and say, well, when was the last conviction? Because that's right in the record. But it's hard to figure out that conviction may be for an incident that occurred 2, 3, 4, 6, however long, sometimes as much as a year earlier, depending upon what. And how do you research, like if you're the state's attorney, how do you find out when the incident was as opposed to the conviction? All I'm saying is it's really easy to go to the record and see when the conviction is and say, was it 20 years until whatever the next conviction is? But it might be hard as a matter of charging to figure out, without going back into the actual documents, to figure out where the incident was. Am I reading this wrong? So honestly, I don't care, but it's, I think that if you go conviction to conviction, it makes it easy to do, because you have 2 definitive dates that are on the record. To get beyond the conviction, you have to dig into the facts of whatever happened to figure out when that was. Am I wrong about this?
I mean, I guess I'm just a little curious. Like, wouldn't that be filed with the charges when it happened?
Yeah, but you have to see it in the information and affidavit. Like, it's not in. It's not in. Yes, it is. Okay. But you could, when somebody runs a record check to see, oh, has it been 20 years since the last conviction? You can see that easily. It just pops up. If you're trying to find out when the incident was that gave rise to the conviction, now you've got to go behind the record to try to figure, to see what's there.
I thought there's usually the charging date on the 29C III document. So
I thought what you meant with this is that you were looking at the incident.
Wouldn't that
yeah,
be
so
charged?
long as the incident is within the 20 years.
Yeah, well, that's right.
Yeah.
But you don't know what the incident is, because charges may come later, will come later than the incident. So if you're looking at what the incident is, it's something other than the charge date. That's why, like I said, I don't really care, but I'm just, to make it simple for everybody, it might be easier to just go conviction to conviction. But like I said, I don't really have a huge.
Yeah, I think though the challenge with that, as far as I'm understanding, is if you're going conviction to conviction, conviction, and the conviction happens several years after the initial charge, then the question is, where does that 20-year block of time, or where do those incidents fall within that 20-year block of time to determine whether or not it's a second or third offense? That's,
Well, if you're just counting from conviction to conviction,
Senator Hope's gonna-
I mean, I'm not trying to muddy
Yeah.
this any.
I mean, I think the Department of State's attorneys and sheriffs is asking for this change, so I think I would defer to them. And I think in a perfect world, people have access to really quick resolution of these things, but that's not the world we're in, and I have concern if someone's sitting for 2 years, they've gotten, like, it should be when it happened, not after they've done treatment. So I also, from a fairness standpoint, but sort of circling back to the underlying question, is it was the Department of State's attorneys that came in and asked us to do this.
If they're asking, I wonder now I'm wondering what's going on. But maybe they haven't thought about it that way. But no skin off my nose, to be honest. I don't care either way. I think it's going to give, I think the incident might be good for defenders, from a, when I was in private practice, I did about 100 DUIs a year when I was in private practice all over the state. And so this is like an issue that's sort of near and dear to my heart, even though I haven't done one in 25 years. Like I said, I don't really care. If for some reason they want it, then fine. Doesn't matter to me. I just don't seems like it might be more difficult for me. But hey, whatever.
Senator Battles?
No, I was just gonna say, in my head, if you go conviction to conviction, if you're within a couple of months or something and you wanna delay that second conviction, so you get then outside the 20 years,
Yeah.
if you're like, I need more time for this
Yeah.
trial.
You can do that, although the other thing that happens is you can delay the, say you have the first one, you have an incident, and now you do some things, maybe you do treatment, you do whatever it is, and your first conviction isn't for 18 months, 2 years after the incident. Your suspension just, and your conditions, you're on conditions of release for 2 years. The bottom line is, you're actually extending to 22 years.
Right.
Your impact.
Right.
So, it's on, however,
Right.
Like I said, it's not, the only interesting thing about DUI, and every time we tinker with it, and when I was in private practice and I was doing these, I loved it when we actually did this stuff. Because it just it was a good moneymaker for private counsel who did a lot of DUIs. Just the litigation around tinkering was always profitable.
Senator Morris, and then we're gonna.
I do have a question for you,
Yeah.
if it's appropriate. I've heard testimony from the state attorney and sheriff, I've heard testimony from the Attorney General's office. I see you're the lead sponsor on this bill. What was your impetus for this? Is this something that someone approached you on, or what are you talking about?
A modest request, I think, a modest request from my state's attorney.
From your state's attorney? Okay.
And it seems like a small change. It seems like the more we talk about it, the more complicated it gets. But, I mean, I understand it. It's just
What was the reasoning from your state's attorney for this request?
what I've described in terms of the, it's unclear, and there's also the issue of going beyond that 20-year timeline inadvertently, or in such a way that's kind of contradictory to what the original law probably intended.
I would definitely agree it needs to be clarified. I agree with your state's attorney on that. And I probably, in the real world, it's more fair to go incident to incident. It's just more difficult to determine when, 20 years later, 19 years later, whatever it is, when the actual incident occurred as opposed to when the conviction occurred. But I don't care.
Quick statement, I appreciate that it might be easier, but I think there's enough unfairness baked into our system. I would really advocate that we go with the more fair, even if it is a little bit more work. I don't wanna bake more unfairness into our already unfair justice system.
Thanks for coming in. Appreciate it.
My pleasure.
Thank you.
Alright, so next up we have
193.
193, Susan?
We need more deadheads.
There aren't enough of us left.
Hi, good morning. For the record, my name is Susan Aronoff, and I do the policy work for the Vermont Developmental Disabilities Council. And if the committee would just allow me a couple minutes to explain, because I don't think I've ever been before the Senate Judiciary Committee. So who am I and what am I doing here? And why do I have a .gov address? So the Vermont Developmental Disabilities Council is a state agency. We are located in the Agency of Human Services in the Secretary's office. All 50 states and 6 territories have developmental disabilities councils. We were created by a federal law. Our council happens to be entirely federally funded. On Disability Advocacy Day, you might have received a copy of our platform in your mailboxes. I have a couple of them to share. Our platform is created by a governor-appointed board, the majority of which has to be people with disabilities and their family members. Our executive director is employed by that board, and I work for her. Our executive director, Kirsten Murphy, happens to be the chair of our National Association of all of the Developmental Disabilities Council. So when we talk about what's going on with like Medicaid or home and community-based services or things like that at a federal level, we're kind of tied in to what's happening. And when we talk about the criminalization of people with disabilities, particularly people who are unhoused and have disabilities, particularly people with autism who might be on registries, our little network here in Vermont is really tied in to what's happening nationally, and I just wanted to share all of that to give you some context for my testimony. Because I'm a state employee and I often, my council often takes positions that are different than what's in the governor's recommended budget or what the good people at AHS are proposing, in order to get our federal funding, as I refer to in my written testimony, we have a current memorandum of understanding. It's updated all the time with the current Secretary of Human Services, Jenny Samuelson, that allows me to testify on any issues related to people with disabilities and their family members, on the positions that our council adopts, even if they're different from the AHS positions. And I always have to say that, sorry it takes so long before I speak publicly, because it won't surprise you. Spoiler alert, the Vermont Developmental Disabilities Council, every time we haven't considered it yet this session in fairness, but last session and every other session when we've considered a forensic facility, another institution for people with disabilities in Vermont, the position of our council has been opposed to it. And I don't want you to think this is just knee-jerk opposition, so I want to explain some of why we're opposed. And after I finish my prepared comments, what I really want to focus this committee's attention on today is the new language you're considering that you're thinking of as a fix to the mental disease and defect. My apologies to anyone listening. When I use words like mental disease and defect, those are the words of record. They are very offensive to the people I serve. So any words that I use about mental illness, psychiatric disabilities, incompetence, ability to be restored, for the record, I'm using the language of this building. Some of those words, like whole departments, were called Department of Mental Retardation. That R word is insulting and offensive. Mental disease and defect, it's insulting and offensive. I understand the desire to fix that, and I applaud it. The conditions language, well intended, doesn't get us there, and I'll explain why. Okay, another piece about my background, so you understand where I'm coming from. Explain where the Developmental Disabilities Council is coming from. The reason why I took Senator Mahosky's nudge to testify today is I rarely have the lived experience that anyone in this building cares about. I bring the people in who are the parents of the people with disabilities or the people with disabilities. I rarely have a lived experience that matters. This is an exception. I've worked as an attorney representing low-income adults with psychiatric disabilities for more than 20 years. I did a lot of that work, some of that work in Vermont. I did a lot of that work, 15 years, in the good state of Connecticut. My office was based at Connecticut Valley Hospital, which is home to the Whiting Forensic Institute. And prior to the atrocities at Woodside, I used to share all the atrocities at the Whiting Forensic Institute as the examples of what in 2017 can go wrong at a forensic institute that was as well endowed. The Psychiatric Security Review Board in Connecticut does not mess around to protect the public safety of the good people of Connecticut. So when they say, I served on the committees that studied this issue in the state, and they used to bring in the people from Connecticut to talk about their successes, their zero recidivism rate. Well, guess what? After 2017, when they had 30 people arrested, now serving time for the abuse of those patients, that boasting and looking to Connecticut as a model dried up. While I was in Connecticut, I taught mental health law at a master's level at the University of New Haven to master's students who were mostly going into public safety, police. This was a famous school for forensic studies. And every year for final exams and midterm exams, I would ask the students to bring me definitions of things like mental disease and defect, and to construct as a team the best fill-in-the-blank commitment statute for someone with a psychiatric disability, the best competency evaluation. And why? Because all 50 states, we all do it differently. We define who's in and who's out differently. We give them their rights differently. So I will just submit that if the state wants to do this the right way, there are examples out there of how you would define a competency restoration program and who's in. And the wise Dr. Regan, who testified yesterday, she, I think, was trying to alert you that a category of people you have to consider are the people who are going to be found not competent. So imagine someone with an intellectual or developmental disability. In Vermont, we still use the IQ score, so apologies to my colleagues, I'm going to use the IQ score. Someone with an IQ that would qualify them for developmental services in this state. There is no competency restoration program in this country, in the planet, that will change their IQ. There's no medication that will make a person who's not competent to stand trial because of an intellectual or developmental disability competent. So you, by this definition, can include people who are not competent and not restorable. And the new change would be to have them only reviewed annually. And the idea of taking disabilities who cannot be restored and holding them indefinitely, and not just holding them indefinitely anywhere. Public safety, you might have to hold people indefinitely. The good people of Connecticut who are going to be holding sex offenders indefinitely, they're building gated communities, actual houses with TVs, real normal houses. If you're concerned about public safety, and I just want to say something about the crime victims. Absolutely. The system is not working. We do not have public safety. We have people who are out in the public who are people in need of treatment. I do not deny those facts at all. Those are facts on the ground. God bless the memory of the late Senator Sears. There was a real problem he was trying to fix. I think he would be the first one to say not put people with disabilities in prison. I spent the last couple of years trying to convince him of his life, trying to convince him that our DOC facilities has as much of an obligation, affirmative obligation to meet the Americans with Disability Act needs of people with disabilities who happen to be in their facilities as anyone else. Because there are people with disabilities who end up in DOC facilities, and they do have a right to reasonable accommodations. But I want to say, based on my experience as an attorney, serving people with disabilities in a forensic facility that operated very much like a prison, you can have a disability like blindness. You do not get a cane in a forensic facility. It's too dangerous. My client was given literally a pink pool noodle that people laughed at. He did not know it was pink. My client, who was blind in the forensic facility, had to rely on the goodness of his fellow, I'll say, inmates to escort him around because there was no staff available during his waking hours to provide what the ADA would have insisted he was provided. One of my favorite cases was trying to get him a service animal when he was moved to a lower secure facility because his service dog, you know this about service dogs, if they're not in use for a couple months, they revert to pets and you got to start over. Well, imagine being someone in a secure facility who wants a service dog. But Delco, like, they came and legitimately checked out the environment at the Connecticut Valley Hospital where this guy was living to see if they could train him on site with his dog. And they concluded a couple of things. They concluded the campus itself, which is very much like the Waterbury State Hospital campus, was an unsafe environment for the dog. It did not have sidewalks, it didn't have crosswalks. The dog would have been endangered there. Just imagine what that says about the patients. Likewise, most significantly, the good people of Fidelco did not think the living environment, no carpeting, no roof, all these various things about the living environment that you take for granted when you work in an institutional setting, literally, and I have this in writing, the living environment would not be suitable for one of their service animals. So what does that say about the living environment? We're suggesting to put people with disabilities in indefinitely if they're not competent, not restorable. The state wants to design a competency restoration program. I would submit that like 40-something other states have them, and they know whose competency can be restored and how. And someone with a brain injury, no. You know at the gate whether or not they're competent, so what does competency mean? This is Judiciary Committee, you probably already know. The ability to communicate with your attorney. The ability to know truth from fiction. The ability to know who the judge is and the other people in the courtroom. So you might teach someone by rote, even someone with an IQ that would qualify them for services, who the attorney is in truth from fiction. But to meaningfully talk to your attorney, that's very hard, even with medication. Other group I want to talk about, having represented them for years, people with psychiatric disabilities who you attempt to restore to competency with psychiatric medication. There is a percentage of people, and I would suggest you bring Dr. Raven back to ask her about these people, for whom there are no known medications that work yet. These people are called treatment refractory. And again, I'm not suggesting that in the interest of public safety you do nothing and send them back to their communities, but if you know you're going to be holding someone for 6 months, a year, 6 years, 20 years, a prison would not be a suitable environment. Likewise, for therapeutic purposes, the people whose competency are restoring, another question for Dr. Freeman, if someone has committed a heinous act and then restored to competency, and they've gained any insight into acts they might have committed, they need intensive therapeutic supports at those times and through that process. And I would submit they're not going to find that in a DOC. So I've heard some of the committee discussion here about does it really matter in the end? Are they, if they're in a hospital or if they're in prison? I would say for so many reasons, but especially for the sake of the people, their lived experience, we are going to be putting through this process. To do it in the most humane setting where they can have the greatest amount of dignity and quality of life afforded to them, whatever conditions they are living with, whatever crimes they have been accused of. I think that Dick Sears, Senator Sears, would have been the first to say that the people that he was concerned about would not be treated in a DOC committee at a facility. I remember how enraged he was when there was one person receiving developmental disability services residing in a DOC facility, and he wanted her out yesterday. And I'll leave it at that. I've probably taken up more time than I can go through in my comments. Oh, the most important thing, sorry, of my comments. So I submitted electronically, and because I'm old and like paper, I'm going to submit physically the story of Grace. This is the story of what happened at Woodside in this state, in this century, in our time, with our current leadership. And the takeaway, what happened, and I would really humbly assert, if you haven't read it, even if you've read it, I hadn't read it in a while, and I didn't really get through it this morning with breakfast, but whoa. Chris Winters, now deputy commissioner, but when he was commissioner of DCF, the day after, yes, this amazing investigative piece about what happened at Woodside, when that came out, he said a couple really serious things, and these are the things that I want to leave you with, because it's not too late to fix this bill to address these issues, but the issue of oversight. It's really different if you're in a prison than if you're in a hospital. Which legal advocates do you have a right to? If you're in a psychiatric facility in Vermont, you have the right 24/7 to the Services of Disability Rights Vermont. Who do you have? Thank you, Defender General Mario, when you're in a prison, and what will they be able to do for you? And who's going to have your back? Is it going to be the conditions that CMS, the Center for Medicare and Medicare Services, sets for how people in treatment should be treated? The right to fresh air, the right to exercise, all kinds of humane and dignified treatment rights that come in the hospital certificate of participation process that are totally absent for correctional facilities. So think about the rights of the individual, oversight, but especially with the Agency of Human Services. I've worked there. I worked at Dale for years. They like to pride themselves on this mantra sometimes, an agency of one. Well, that could be great if only true from a policy perspective, but it could be effective, collective impact, all of that. But when you're talking about the same facility, determining who goes in and who goes out, and also operating and also providing oversight, that is exactly what Chris Winters warned about after an experience with what happened with Woodside. And his big takeaway was there must be transparent oversight and accountability for the entire system, but more so at higher levels of care, particularly any locked and secure sites. And the state cannot be both the ultimate regulator and the provider, and those aren't backwards. That's the quote of former Commissioner, DCF Commissioner Chris Winters, when he was trying to understand how was Woodside allowed to happen for 7 years. Judges said, okay, so many people in power, look the other way. I know you guys weren't in these seats then, but as a Judiciary Committee, I think you would want to reacquaint yourselves with what happened and then bring those eyes to bear on how can we prevent this from happening for people who might not even be able to speak. Certain people with intellectual and developmental disabilities, some of the ones that I bring to the building as my guests, they use facilitated communication, augmented communication. How is that going to work in an inpatient setting? Who's going to cut up their food and feed them in a feeding tube and change their adult diapers. How is that going to work in a correctional setting? And sincerely, one population, another question for Dr. Raven, to talk about the needs of how you have Connecticut address the needs of these folks. There's a certain subset of people who end up not competent to stand trial because they participated in a murder attempted suicide. I say attempted suicide because one of my clients in Connecticut who was in such a situation committed a murder and attempted suicide was then using a wheelchair and was in diapers and all the other things I described. And the state of Connecticut was trying to care for him with their normal staff in the forensic facility. And it wasn't going really well. So the state of Connecticut opened a nursing home, a secure nursing home, which I understand Vermont now partnered with the same organization to open one in Washington. Because the needs of our imprisoned population, they are aging just with the rest of us. And there's a lot being done. Commend you to the work of a social worker named Tina Mash, who's written extensively on this topic. How do you care for people who are aging compassionately in prison settings? Well, one answer is you don't. You put those same people in a more compassionate setting, more appropriate to their needs. Maybe they all get, in suite bathroom, just whatever an elder might need, aging behind bars, a person with a disability might need, who's not competent to stand trial and not guilty by reason of insanity, but has a very serious and the law has to be met, support needs, 24/7. So I'm going to spare you my written comments. Areas that I think you would really want to focus on, the definition of who's in and who's out, because this wide open door of any condition, however required, aside from I thought being a little grammatically wobbly, it just means you're capturing a net really wide to bring into a facility for restoration or to be held for indefinitely a large group of people who you will know at the gate are not capable of being restored, and there is no plan B.
Susan, thank you. Am I right that you're talking about that phrase that's been substituted throughout qualifying condition?
Yes.
So that was, as I saw it, an attempt to get rid of the language that you found offensive.
Yes.
So you don't like either of those. What might you suggest in their place?
Yes. I think I would go to the what problem are you trying to solve? So if the issue is competency restoration, I would include a definition of people in the definition of people whose competency can be restored at a minimum. And that would exclude people with certain dimensions, people with certain brain injuries, people with certain, and not all necessarily intellectual developmental disabilities, but certainly I don't think you want to put anyone into a competency restoration process who at the gate, 95%, 80%, not going to be competent or skillful. And the other thing is, in other states, there is now there are larger populations, I get that, with larger state agencies, but there are much higher walls maintained between, well, first of all, between correctional facilities and treatment facilities. Treatises have been written about that, but also between people with different types of disabilities, and whatever I might think about that, in certain states, people with intellectual and developmental disabilities are not allowed by definition to be admitted into these psychiatric facilities. And for some people, it was their ticket out into a different, in some ways, more enriched service system. So I would consider the wisdom of mixing populations. That said, I just want to say for all people with disabilities in a forum, I think this committee knows far more likely to be victims of crimes ever than perpetrators of crimes, and particularly people who have been labeled with psychiatric diagnoses and especially in these facilities, not just in Connecticut at the Whiting Forensic Facility, our good friends in New Hampshire are struggling with lawsuits. The people who were held and abused in their state-run facilities.
So, thank you. I think one thing I just wanted to make sure is clarified here is that I don't know that this necessarily casts as big of a net as folks may think that it does, because this would apply to individuals who are charged with life offenses and they're being held without bail. So they'd be in the jail already, but not going through any sort of competency restoration program. But I think the challenging piece that you've raised, which I'm trying to figure out how to navigate as well, is if somebody is unlikely to be restored to competency, then what happens to them? And I think that could apply to instances where, the rare instance where somebody isn't held without bail, but also charged with a life offense, and there's a finding of no competency. And so I'm wondering if adding in language on page 3, somewhere around line 14, that if somebody is unlikely to be found competent and they're not already being held without bail, that the court shall consider less restrictive means, like the Berlin Psychiatric Hospital.
So to address the first question of who would this apply to, so one thing that I don't think I've heard our committee discuss very much is the existence of the parallel Act 248 process. Does that come up in the? Yes.
Yes.
So in my written comment, I just want to say that way back in the Wayback Machine in 2010, discussion of perhaps having a forensic facility for people with intellectual developmental disabilities was raised and studied, and in my written comment, I quote the then wise Commissioner John Senegal about why grouping people with these kinds of disabilities together in a similar facility would be both not therapeutically appropriate, but also probably not cost effective, and that the better thing to do would be to have small, secure programs in communities. So what you're saying about Berlin, I would even shift that. So I worked with a gentleman who had been held in the Whiting Forensic Facility in 4-point bed restraint 24/7 for more than a year, in violation of every CMS rule in existence at the time. When CMS came to the hospital and found him out of compliance, this gentleman was flown across the country to California, where he lived in the community in a house, but he had 3-on-1 staffing. And yes, his house had a secure room for the staff. They had protocols they would follow around taking this gentleman into the community. But I visited him in the community. I have pictures of he and I listening to music in the Barnes and Noble. So I would say that even people who would fit that definition of charged with a crime, they, can still be safely, can still live safely in the community safely protected, if Vermont had rules and tools to do that.
Well, I think,
Was that your question?
I think the distinction, though, is that if somebody is found to not be safe with their community, if they're released to their community, that's the issue.
So, right, so that's what I'm saying. There are people who might have been appropriate under the definitions to be admitted into a forensic facility, but what the holding of the Supreme Court case in Olmstead said was where the state is providing services. So sometimes when you think about people with disabilities, when you think about, I know you guys are kind of thinking about all this from the state's power for public safety and how do you protect the safety of the public. Once the state has a person with disabilities in its control, and the state is the guardian, the caretaker, service provider of that person, they're doing it either in their loco parentis, the place of parents, the duty to care, to take care of someone who cannot take care of themselves. That was the most humane reason ever created for our institutions, for anything the state does. The other authority, parents patriarch, is a more controlling authority. Whichever one you're gonna root it to, whether you're gonna take care of people in the community or force them into treatment in the community, I would submit you would have the right and the duty to do both. But I would say that states can and have found ways to keep the public safe and to not keep people behind bars indefinitely. Those are not the two options.
I think the
I
other
mean,
piece,
the client that I had who had 3-on-1 staffing, he did not have 3-on-1 staffing forever. So a good behavioral modification program will work on reducing that over time so that that person has a chance for community integration and a life. When I met him, he was in his 20s, but he's gone on to do so many other things after having spent a year 24/7. He put 23 staff out on comp. He was not a good boy.
the other piece that I had brought up at the beginning of this entire bill is also making sure that if this were to be a forensic facility that's in a DOC facility, that any individuals who fall into these categories are separate and apart from the general population. I don't know if it's actually.
Okay, can I just say one quick thing about that? The separate and apart thing. I meant it, please. One woman I represented was the only woman on her unit at the Whiting Forensic Department. What that meant effectively for her, and she was a young black woman, again, a civil patient in the forensic department. Same people you're talking about here. What that meant was she was essentially in isolation, in solitary. They actually ended up moving a woman from the other part of the hospital that was not the forensic hospital over to the more reserved, like a jail. You go in and out of gates and can't bring a pen, forensic maximum security, so she wouldn't be the only woman. So yes, separating people from a population is great as long as it doesn't further inflict damage or harm upon them. My former agency brought a really successful sex discrimination case for the failure of the state of Connecticut at that time to provide effective services for the women in their custody.
Senator Bowles.
Yeah, I'm just wondering if you have concerns around the effectiveness of treatment and restoration if the staff is armed guards and I mean, you can have a separate wing in a jail, but the setting is still a jail. And I'm wondering if that concerns you about the treatment capacity.
Yes, and yes. So in general, and I think that the draft does a good job of capturing the state of the Supreme Court law on who states can involuntarily medicate if the state has an interest in restoring someone's competence. I think that that's well captured. I think where and how the state chooses to exercise that awesome power is really significant, both on communicating what the state thinks of the person whose rights they're able to violate, their bodily autonomy, they're able to violate with drugs that upon first dose can cause permanent and irreversible side effects. I think, and Dr. Raven would be an expert on this, not me, I think that when she said that competency restoration has been more successful in inpatient settings than in the community because of issues like housing and food and the other things that get in the way of compliance, I would ask her to consider some of the studies that have been done on people when those needs are met, and in particular, the recidivism rate in Connecticut for sex offenders when they're under community supervision better and have work and have opportunities, their participation rate in treatment and their recidivism rate is just remarkable. And again, defer to Dr. Rubin on that, but I think that any treatment is going to be more successful when the person treated is as engaged as possible in that treatment, and then more likely to engage if they're being respected as humans.
Just gonna interject with a quick note for my committee assistant.
Yes.
If you ask Senate Health and Welfare to look at the qualifying condition language, please. I do think that is one that falls into their wheelhouse. Thank you. Sorry to interrupt, I just didn't want to forget that.
Yeah. The thing about being able to work with difficult people in the community is the community providers need to be better resourced in order to do that. And one thing that I saw done very successfully in Connecticut is that the providers, similar to our designated and specialized services agencies, they were going to work with someone being discharged from a forensic facility or was involved in this forensic system psychiatric security review board oversight. They were given extra resources in order to accomplish that, and they would be given Connecticut created state-funded rental assistance. Some of the people who got highest priority was for people leaving institutions under the supervision of community providers. Because of things like what Dr. Raven expressed, you can't expect someone to be successful in treatment if they're in a shelter or if they're out of the street. And so food, clothing, housing, shelter, all the social determinants. The agencies that supported the people in the forensic system, I've been told not to use this word, but it was like sometimes they would come with a dowry. It made it possible for the agencies to serve them the way they needed to be served. 3-on-1 staff is not cheap. I'm not pretending it is. It's a lot less expensive than an inpatient bed indefinitely, and a lot better for the person. But our agencies, as they're funded now, are designated specialized services agencies, can't be expected to take on the risk with the resources that they need.
Thank you. Maybe any other questions or comments?
When are we having roll happen?
Yeah, I made a note actually, because we haven't heard. Have we gotten any list of witnesses from WellPath? WellPath, the medical providers for DOC.
Okay, I just want to make another comment about that, because I think that this could be fixed in the directive, is the area of oversight, a patient's right to sue for rights violations sometimes really depends on if they're being provided services by a state contractor, or by a state agency, or by a hospital, or by a prison. How much right to health care does someone have? So I would just encourage you to, if you're concerned about the basic civil rights and the ability to detect abuse of those rights, to write in what kind of oversight, who are the eyes on, what kind of rights do people have, and to take Commissioner's Winter's words to heart and provide for independent, outside of AHS eyes on.
And what would you, I mean, if you were, if you were the drafter, what would you say oversight looks like specifically? As in, who would be on such a oversight committee or council?
Yeah, I think to me, and again, the story about what happened at Woodside is so instructive. Even the Attorney General's office, T.J. Donovan, knew what was happening at Woodside while it was happening. So I would have to think who's outside, because ordinarily I would like to say, oh, the attorney, some outside of AHS, but I think it would actually have to be outside of the wrong statement. The Defender General might have an opinion, phoning a friend. I just want to say, in terms of resolving the issues at Woodside, there was no office more instrumental in righting those wrongs than the Office of the Defender General.
Anything else for our witness? Questions or comments? Thank you for your time.
Thank you.
So we're doing 186 on your drive. And when you're also here for 179. Right.
Today?
Today.
Right, yeah.
Okay, all right. So, Mark, do you mind if we take a 7-minute break, come back at 11:20? Does that work?
Absolutely.